Have you ever been asked to sign a non compete agreement as part of a job offer? You may have agreed to it without fully understanding what it means for your career. But what happens if you want to leave your job and join a competitors? In this video, we will dive into non-compete agreement, why they exist, what they really mean for your future, and how to protect yourself if you are asked to sign one. What we will learn, what non-compete agreement are and why employer use them. The key components of a non-compete agreement. How non-compete clause impact your future employment opportunity. When a non-compete agreement is enforceable and when it's not. How to negotiate or avoid restrictive clause in a non-compete agreement. First is, what is a non-compete agreement? A non-compete agreement is a legal contract between an employee and employer, where the employees agree not to work for competitors or start a competing business for a specific period of time after leaving the company. Why employer use non-compete agreement? Employer use these agreement to protect their business interest. These include preventing employees from using proprietary knowledge, trade secret, or relationship gained during their employment to benefit competitors. Why are they controversial? Non-compete agreement can limit employees' career mobility and earning potential. While employer guide that they protect their business, employees feel they can be too restrictive, especially in industry where there is a shortage of a skilled worker. Key components of a non-compete agreement. First is duration. Non-compete clause generally specify how long an employee is restricted from working for competitors after leaving the company. This duration can range from a few months to a few years, but it must be reasonable for it to be enforceable. Geographic scope. The agreement usually outlines a geographic area where the employee is prohibited from working for a competitor. The scope must be reasonable and tailored to the employee's role. This means a reasonable manager might have a larger geographic restriction than a local scale associate. Nature of the work. Non-compete agreement often specify what type of work or industries the employee is restricted from joining. This may vary depending on the employee's position and the company's competitive interest. In enforceability. To be enforceable, non-compete agreement must be reasonable in terms of duration, geography, scope, and job functions. Courts generally favor employees, so agreements that are too restrictive may not hold up in court. When are non-compete agreement enforceable? Reasonable time period. In most cases, non-compete agreement must last for a reasonable period of time. A clause that restricts someone from working in their field for 10 years is unlikely to be upheld. A 6 month to 2 year period is generally seen as responsible in many industries. Reasonable geographic area. The geography area covered by a non-compete should also be reasonable. A global restriction on working for competitors might be excessive for a local employee but could be valid for an executive or senior leader with access to a broad network. Protection of legitimate business interest. Non-compete clause must protect legitimate business interest. Employer must show that their business secret or client relationship are at risk, not simply that they want to restrict competitors. Public policy consideration. In some states, court may strike down non-compete clause that they feel unfairly restrict an employee's ability to earn a living. A state like California generally do not enforce non-compete agreement, viewing them as an unreasonable restriction on employees. How non-compete agreement affect your career? First is career mobility. One of the most significant impact of a non-compete agreement is that it may limit your ability to pursue career opportunity with competitors. You may have to wait until the restriction expire, or you might have to negotiate with your former employer to get a release from the non-compete. Job search limitation. In some cases, you might find that the non-compete agreement severely limits the companies or industries you can work in. This can be especially problematic in highly specialized field where job opportunity may be scarce. Income impact. If your non-compete agreement limit where you can work, it can impact your earning potential. You might need to take a lower paying job just to avoid breaching the contract, or worse, be unemployed for an extended period while you search for a non-competing role. Negotiating or avoiding a non-compete agreement. Negotiation tip. If you are asked to sign a non-compete agreement, you don't have to accept the term as they are. Here are some tips for negotiation. First is limit the duration and geographic scope. Clar- Clarify the type of role you will be restricted from pursuing. Ask for compensation in exchange for arranging to the non-competes. Avoiding a non-competitor. If you are offered a position with a non-compete agreement, you may have option for avoiding it. You can negotiate for a higher salary or additional benefits in exchange for signing. Consider working for a company that does not require such clause, especially in a state where non-compete agreements are not enforceable. Have you ever signed a non-compete agreement, or are you currently negotiate one? Share your experience or question in the comment below. Don't forget to like, subscribe and hit the bell icon for more video like this. Let's keep the conversation going.